I'm delighted to be here today. It's an honor to be asked to address this group about the question of innovation. There's always a temptation in dealing with innovations in the judiciary to look too far into the future. So when we consider legal, technical, and organizational innovation, it's especially tempting to describe a scenario where the legal innovation is that legislation is utterly clear and unambiguous, so there are no problematic points of law to decide. On the technical side, it's impossible not to imagine a paradise where artificial intelligence sifts through all the documentation and all the evidence in a particular case, excluding the irrelevant and presenting the judge with a neat package of undisputable material facts. On the organizational side, one longs for the day where the judge's working week is organized so that she or he hears a case and is immediately given time off to write the judgment without having to plunge into another hearing about an entirely different matter. Of course, desirable and all as those things may be, the scenario where they're all achieved simultaneously is some distance in the future, to put it mildly. They also present ethical issues, particularly with regard to the use of artificial intelligence that's been debated earlier on today, and I'll touch on it, albeit briefly, later in this speech. For the purpose of this paper, I'm going to focus on practical examples of how judicial councils and judiciaries around Europe have used innovation in order to improve access to justice and the quality of the experience that litigants have when they encounter the justice system. It's easy for me to do this because the ENCJ, the organization I represent here today, has recently carried out a survey among its members on the question of innovation on the part of judges. The first slide shows the questions asked, and you can see what they are. The relevant ones, I think, are 1, 3, 4, and 5. Firstly, councils of the judiciary and similar bodies throughout Europe were asked whether their council has an established policy or framework to encourage innovation that contributes to the efficiency of justice within the judiciary. Are the strategic objectives your council or alternative governing body has identified to improve justice through innovation? At 3, which do you consider to be the most valuable innovations of the judiciary, and explain why that's so? At 4, what are the pressing needs of the legal professions, judiciary in particular, but not limited to judges, that in your opinion could be addressed through innovation? And then, are there any dangers or limitations of such innovations that you could foresee? And linked to that last question is number 5. In your opinion, what challenges, if any, does the judiciary in your country face in relation to legal innovation? The response was received from the list of countries you can see on the screen now. It's an impressive list of countries and states throughout Europe, which gives a particularly full overview as to the role innovation among judges plays across the continent. I should say that Cyprus should also be added to the list, and we'll come to Cyprus in just a moment. One notable exception is the lack of a response from Ireland, Scotland, or England and Wales. The perspective of jurisdictions with any element of a common law tradition, therefore, is to be found in the contributions of Cyprus and Malta. However, as a member of the Judicial Council in Ireland, I'll obviously draw on Ireland's experience in the course of this paper. I arranged the paper under 3 broad headings. The first is appetite for innovation. The second section covers examples of innovation in a number of different levels. And the third theme is to tell you something about the Award for Positive Change, a competition which took place among members of the ENCJ this year at our annual meeting in Rome. So, appetite for innovation. The public perception of judges varies to some extent across Europe. One popular belief in Ireland is that judges tend to be very set in their ways and resistant to change. I couldn't help but notice that Judge Des Pasquale in his question and answer session referred to judges as potentially conservative. And I also noticed that Dr. Lenke used the same phrase about the legal profession, though the impression I got is that, in his view at least, judges are the more conservative cohort of individuals. Possibly the most famous example of the extent to which judges are perceived to be out of touch is a story, which may or may not be true, of the English High Court judge who asked the barrister during the course of submissions, "What is a T-shirt?" The view that judges are in some way out of touch with society live according to ancient and old-fashioned rules, and are instinctively unhappy with innovation and change is simply wrong. One striking result of the ENCJ survey is not just that judges are open to innovation, but that there are formal structures in place in a number of countries to encourage change. For example, Portugal, Denmark, and Norway have either developed strategies or set specific strategic objectives for innovation and change. Norway has its own strategic plan, Courts 2027, which sets out in broad terms what objectives with regard to innovation are to be achieved by the target year. Some jurisdictions have dedicated teams devoted to stimulating, facilitating, and directing innovation. Once again, Norway has a dedicated department in its National Courts Administration, which is described as the, quote, Department on Innovation and Court Development, unquote. In Sweden, individuals from different departments of the National Courts Administration form a group dedicated to leading innovation and developing novel and imaginative solutions to current problems. The Netherlands has an innovation steering group with very much the same objective. And in fact, towards the end of my talk, I'm going to come back to an example of what's emerged from that group. Other jurisdictions have taken a more grassroots approach. This is to some extent more bottom-up than top-down. Members of the judiciary are actively encouraged to submit suggestions for innovations that are then considered and, if thought to be good ideas, are frequently implemented. For example, in Denmark, court employees are encouraged to bring creative solutions both to their colleagues and to those occupying more senior positions in the justice system. The solutions are then assessed, can often form the basis for innovative measures, and the person putting forward the solution gets the kudos for doing so. In Austria, the Association of Judges regularly calls for suggestions from its members, and these are presented to the Austrian Ministry of Justice and have often been implemented. To return to top-down innovations, in June of this year, an OECD report entitled Modernization of Justice in Portugal was presented at a public event in Lisbon. This recommends a host of changes in the judicial system in Portugal, including improving the ability, quality, and use of statistical data and systems, as well as using digital technologies to improve accessibility, efficiency, and responsiveness. If one looks behind the slight use of management speak and corporate language, what's suggested is very clear. The report recognizes the importance of collecting data about how the system currently operates, and then using that data to improve the experience of court users. Traditionally, some court systems, and I would include Ireland in this, have not been effective collectors of data. Clearly in Portugal and hopefully elsewhere, that's going to change. I want to give another example of top-down innovation which doesn't feature in the survey. Similar to Portugal and Ireland, after a lengthy process involving the OECD, a judicial planning working group has been set up to produce a template for improving the administration of justice. This involves absolutely everything, from judicial resources through to, again, better data collection and management, as well as improving the services to court users in a practical way. Importantly, the process has resulted in the rolling appointment of more judges at every level of the Irish court system, because Ireland had, according to the OECD, the least number of judges per head of population in Europe. While it's early days, so far the implementation of the recommendations of the working group have been positive. These are just examples that I've culled from the survey results in respect of Ireland from my own experience. It gives the lie to any perception that judges are so conservative that any change or innovation will be resisted. People don't become judges to provide a service that's not up to scratch. If and when that happens, it's usually the result of other factors pressing in on the judge. Judges want, as fully as they can, to fulfill their central role in the judicial system. Any innovation that improves the way in which the courts operate is clearly welcome. The appetite for innovation is very, very real. I now turn to the second of the themes. These are specific innovations in a number of different areas. The first area is institutional. This may seem exceptionally dull, but in fact, having the correct court structure is an important part of serving the public through the efficient administration of justice. One example is Cyprus. In July of last year, the Supreme Court in that country was split into two bodies. One deals with administrative cases and the constitutionality of laws. The second deals with appeals in civil and criminal cases. This allows more focused organisation of litigation between those two entities. At least as important as the establishment in Cyprus of a national court service responsible for management and administration of the court system. The creation of a centralised court service is a really helpful way of ensuring efficiencies in the system and the maintenance of a consistent level of quality in the provision of court services. The recent developments in Cyprus are an example of structural overhaul. However, innovation doesn't require such a radical change to the system in order to improve it. One obvious innovative step is to have courts dealing with specialised types of cases where that's justified. It's difficult to imagine a more worthy candidate for expert courts than cases involving domestic violence. In Spain, there are now special procedures for dealing with victims of gender violence. Similarly, in France, some courts have set up specialised units, bringing together judges and prosecutors to deal with cases of domestic violence. These judges are experienced in this sort of case, which provides a focused and effective way of dealing with what are important, delicate, and challenging matters. On the institutional side, I should also mention developments in terms of the establishment of judicial councils in different European states. Very recently, a council for the judiciary has been set up in Cyprus. Similarly, such a council has also been re-established in Luxembourg. Both councils joined the ENCJ in June of this year. The debate as to whether or not such councils should be established is ongoing in Estonia and in Sweden, though both countries have observer status at the network. Not surprisingly, it's the view of the ENCJ as a network of judicial councils and similar bodies that a national council, which allows for the self-governance of the judiciary, greatly strengthens the independence of the judiciary and therefore the administration of justice in an efficient way. It may seem slightly peculiar to describe a judicial council as an innovation. In many countries, there have been such councils in place for a considerable time. However, it wouldn't be right on an occasion such as this to ignore the fact that in some jurisdictions, judicial councils constitute innovations which really do help in a practical way the administration of justice. To give just one example, and again from my own experience, the Irish Judicial Council was only established in the last, I think, 3 or 4 years. It's already been exceptionally active. In particular, the Council has provided guidelines on personal injuries awards, which have played a large role in fixing the amount of compensation that's to be paid for each particular type of personal injury. That's had the very practical effect of allowing people who've been injured in road traffic or industrial accidents to know pretty accurately at a very early stage what sort of damages they're likely to be awarded if the matter goes to court. Because both plaintiffs and defendants know the guidelines and the fact that they're almost always followed, the early settlement of cases is more likely to take place, less legal costs are incurred, and insurance premiums should logically decrease. That's at least how one hopes the publication of the guidelines will operate, but it's also an example of how in practice a judicial council, by its establishment and by its activities, can instigate innovation which is of assistance in the administration of justice. Now I want to deal with procedural innovations. Except for specialized courts, like the family courts I referred to earlier, judges are often expected to deal with a wide range of different types of cases. Either in their judicial training or in their previous practice as lawyers, it's very unlikely that judges will have been exposed to every branch of the law that will now crop up before them when they are on the bench. Increasingly, over the last number of years, different jurisdictions have established handbooks which will equip a judge to deal with a case in an area of law with which she or he is entirely unfamiliar. In Sweden and Norway, the handbooks are developed in close cooperation with the presidents of the court. In Finland, a cooperation network between judges has been created. And I was struck once again, listening to the speeches earlier on today, about the stress placed in particular by Judge De Pasquale on the advantage of cooperation. This is now cooperation between judges. And it has resulted in a data bank for handbooks on different areas of the law. The data bank is filled with contribution by judges who have expertise in that area or in that particular procedure. And it assists those who are new to that area to navigate it. The concept of a judicial cooperation network in itself is a potentially important innovation. Often judges sit alone without input or assistance from colleagues. A network that allows judges to research and consider legal issues could help in coming to a view about the correct decision in a case. It hardly needs to be said that any such network would only operate in the abstract and would not in any way involve removing from the judge the responsibility of deciding the cases. However, as a way of educating a judge about particular issues and procedures, the judicial network idea is an attractive one. It should also lead logically to a consistency in judgments, to an improvement in the quality of the judgments, and also in a speedier judgment, given the ability to source information from a network such as that. When the judge is writing the judgment, some jurisdictions provide templates of model judicial decisions. These are available in Spain. In Sweden, electronic case systems are available, which may provide certain types of texts to be used in decisions. Of course, the existence of a template or a model doesn't relieve the judge of doing the hard work of deciding the case and writing up the judgment. But following a template, if one is available, can be a real help in accelerating the writing up of a judgment and once again ensuring a consistency of approach which is valuable to lawyers and to litigants. The use of alternative dispute resolution is a growing feature of the litigation landscape. In Ireland, the Mediation Act 2017 requires a lawyer to advise the client before proceedings of any sort are launched about the possibility of mediation and the benefits that mediation might bring. If the lawyer doesn't certify that the client has been advised in this way, the judge handling the case is legally obliged to stay the proceedings, to stop them in their tracks until that is done. Even more radically, in Denmark, one of the greatest pressures on the judiciary is the length of time it takes to process cases. To address this, there is now an automatic consent to participate in judicial mediation when starting a civil case. In other words, by commencing the civil case, you simultaneously, and I think inevitably, I wouldn't pretend to be an expert on Danish law and procedure, but you consent to a judge mediating the dispute. Obviously, that's designed to drive settlement of cases. I think there is an interesting debate to be had, incidentally, on the use of judges as mediators, but this isn't the place for that. In any event, whether the mediator is a judge, a lawyer, or someone else entirely, the initiatives taken in Denmark and Ireland are worth noting. I suspect that they're not unique. Leaving aside the encouragement of mediation, which is an important innovation in itself, the introduction of these procedural rules means that mediation is much more likely to occur, cases settled earlier, judicial time and resources are freed up, and there's finality as far as the parties are concerned. In addition, the legal costs are significantly reduced. On a separate topic, litigation has become increasingly complicated. Just as with family disputes in Belgium and domestic violence court units in France, specialized commercial courts have been introduced in a number of jurisdictions to deal with complicated and valuable business disputes. Portugal has gone one step further with the introduction of IT systems to deal with complicated cases. Once again, I wouldn't purport to be an expert in the operation of the ALTEC or the SIP system, but according to the Portuguese response to our survey, it's designed to leverage technology and specialized support that allows a judge in managing the case through to trial, no matter how complicated it is, to do so effectively. And these particular systems are designed to deal with complex cases or to assist in the management of complex cases where there are significant legal issues, where there are a great deal of witnesses, or where no doubt there's a great deal of procedural complexity. Other increasingly frequent types of litigation are class actions and mass lawsuits. I believe these are different in one important way. The class action will often involve a single claim going to trial, though it will govern the cases of many other litigants. Mass lawsuits can best be described as a large amount of claims which all involve broadly the same thing. I think, though I'm subject to correction on this, that mass lawsuits have arisen, for example, from the purchase of diesel cars, which weren't thought to be at the level they should be. I'll put it as neutrally as that. Germany has sought to address the management of this type of litigation by considering the possibility of using AI to manage the workload. Spain is carrying out a fascinating pilot project. And again, this has a resonance of the predictive justice approach described by Judge De Pasquale in his paper. Spain is working on the development of a generative AI that would allow judicial decisions to be automatically summarized. That's true of all of them. When you've done that, it's possible to detect repetitive judgments. So judgments on the same thing, the diesel car, for example. And that allows, and the way it's put is important, potentially to facilitate the automation of decisions where the relevant facts are identical and where exactly the same legal principles are engaged. Now, I said that's a pilot project, and it'll be fascinating to see how it develops. And in particular, it will be interesting, to put it very mildly, to see whether or not the independence of the judge is preserved during the course of that process. So that is the cutting edge of innovation, I think, as Judge De Pasquale described earlier on. I just want to touch very briefly, because it's been mentioned earlier on today, on organizational innovations. Since trials began, there have been note takers involved in recording what is said. Frequently, from the perspective of the judge, it's critical to have a fully accurate record of the evidence in cases and of the submissions made on behalf of litigants. The introduction of digital court proceedings and the audio recording of hearings have significantly assisted on this point. I'll come back to that. As a result of the COVID-19 pandemic, as we heard earlier on this morning, the conducting of remote hearings became a necessity for many of us. My own very personal view is that a physical hearing is potentially preferable, not least because the inevitable loss of connection and freezing of images that we all got used to during the pandemic is avoided when everyone is in the same room. But the use of remote hearings worked perfectly adequately. Remote hearings, as we heard earlier on today, are here to stay. And again, judges have embraced the dramatic change in the way in which hearings were conducted, initially because of reasons of health with the coronavirus pandemic, and more recently because of the advantages it gives in terms of transparency and access to the court. To return to the recording of court hearings, the audio recording of court hearings currently takes place in Lithuania, Estonia, Ireland. It's under preparation in Croatia, and Bulgaria once again have gone one step further by developing, or currently developing, a voice-to-text software that may dispense with the need for note takers completely. Now, while these tools assist in allowing people to participate remotely in hearings or in recording what's actually said at hearings, they don't really assist in allowing the judiciary to reach out to society. The administration of justice is central to society, but as I've already said, judges and courts and all of the systems that surround us can seem remote to a lot of citizens in different states. A number of judicial bodies have tried to address this, and I'll give just two examples. Debt is a problem, which can and often does lead to a range of other difficulties, such as poor health, difficulties with relationships, petty crime, or worse. The Netherlands has adopted a community justice approach that involves simplified civil proceedings. It's also based on the view that cases often cover a multitude of problems, not just the one issue that causes someone to be before the court. The approach includes debt management precisely because debt can be at the root of many problems. And I just want to look at that last element in some small level of detail. This is from the entry by the Netherlands to the ENCJ Award for Positive Change Award. The Award for Positive Change. And you will see the take-home messages from this slide are the amount of households in the Netherlands struggling with problematic debts, almost 750,000. The third bullet point, the significant impact on the lives of individuals, families, and children that debt can have. And then the final bullet point, and this is the most relevant one, the court is an identifier for individuals struggling with debt. And this is how it works. This will be very difficult for you to read. So if I can get my own hard copy, the relevant portion is the box at the bottom of the page. And I'll just set out what it says. It says, the debt officer. In 2022, the judiciary decided that all courts will employ debt officers. How does that work? If during preparation or at a hearing, it appears that one of the parties is struggling with problematic debts, the debt officer, who is trained and appointed in the court, directly engages in a conversation with the person concerned. If possible and desired, the person concerned is returned to the municipal debts, is referred to the municipal debt assistance service. The person concerned is given an appointment there as soon as possible to receive help with the debt issues. The deployment of a debt officer has no effect on the course of the court case. So it doesn't change the rights and wrongs of the individual piece of litigation, but it does involve an intervention, in my experience, of a unique sort, which allows the court to be used as the device for accessing people in real difficulty and referring to them where they can receive help. It's worth noting that the whole concept of the socially effective justice system has come from the Dutch Innovation Steering Group I mentioned at the start of the talk. That's tasked with stimulating, facilitating, and encouraging innovation. It's another example of the way in which the need for innovation is baked into the operation of a national judiciary. I want to look at one other example of the judiciary reaching out to establish links with the community. Like many other countries, Austria is often challenged the recruitment of judges and keeping people in the role. It's therefore established a career portal for people who are interested in becoming judges. More relevantly for current purposes, it has launched a widespread advertising campaign online, also by means of social media, and also, in fact, on television. For any of you interested in becoming judges in Austria, I'll arrange for the link to be made available with the paper. But this is the sort of campaign that creates an interaction between the judiciary and society, which is extremely valuable. It brings the court system and the judicial career into the lounges and laptops of the ordinary citizen, makes the whole justice system more immediately relevant. On top of that, Austria has a Justice at School project designed to inform school students about the importance of the judiciary and to interest them in working in the court system. Too often, citizens think of courts as frightening and intimidating places, and to some extent, that may have been what they were originally designed to be. However, these innovations in Austria and the Netherlands show that integrating the court system in society can be done in a much more positive and ultimately effective way. And I want to go to my third theme, which is the ENCJ Award for Positive Change. I've already described the Netherlands entry. The entry from England and Wales was a bench book or a handbook. And then just to give you some idea as to what that was, a guide for judges, written by judges, but most importantly on the third bullet point, a public document, often relied upon by members of the public, although not aimed at them, but it's subject to public scrutiny. And the equal treatment that's involved here, that the handbook is designed to facilitate, is set out in the following chapter headings. Litigants in person, for example, children and young people and vulnerable adults, people with a mental disability, people with issues of capacity, and so on. It's a good example of the use of innovation to make sure that people before the court are treated in a way which is appropriate to the modern world. Secondly, there was an entry for the ENCJ Award for Positive Change from Bosnia and Herzegovina. You'll see immediately what that is. My Guide to Criminal Process. It's worth noting it's directed to teenagers who are caught up in the criminal process, either as victims or witnesses. It really is difficult to overemphasize, as all of you will understand, the need for careful treatment of such children. It describes, in simple terms, and authored by a judge for minors, a psychologist from the prosecutor's office, and as you can see, an illustrator, all of the things that a young person would need to know when involved in criminal proceedings. And it also sets out in a simplified manner the relevant legal provisions relating to their testimony. Now, the one striking thing about this is that this is not dependent on cutting-edge technology. This could have been done at any point in time, but involves a creative and clever solution to the problems faced by young people in participating in the criminal justice system. And finally, the last entry in the ENCJ award that I want to bring you to are these guys. These are courthouse dogs, and it's an initiative that began in the United States. It's been taken up in a big way in France. You may remember the horrific mass shooting at the Pulse nightclub in Orlando, Florida in 2016, when 49 people were killed. Dogs like these were used to comfort relatives of the victims. In the United States court system, and now in France increasingly, for people who need them, they're available where required. They have, for example, helped victims of abuse or other vulnerable individuals who can be very stressed by the experience of taking part in court proceedings. The dog accompanies its human client throughout the judicial process. As of earlier this year, over 200 victims had benefited from the support of the court dogs. As the final slide shows, the judicial assistant dog is active all over France, with plans to expand the scheme further. The paw prints are the potential areas. The other markings are where the scheme has already been used. And like the Bosnia-Herzegovinian project, this shows that you don't need artificial intelligence, laptops, or robots to produce an innovation that's incredibly valuable and utterly worthwhile. Now, the winner of the ENCJ Positive Change Award this year was Spain, none of the ones you've looked at. In the hope it will incentivize you to come back after lunch, I'll say a few words about that project in the first roundtable discussion this afternoon. But for the moment, I just conclude on 3 points. Firstly, the willingness of judges to engage in meaningful and useful innovations for the purpose of enhancing the administration of justice for all concerned. Secondly, you'll remember that one of the questions of the survey was challenges and difficulties. I'll just summarize those very, very briefly. Some related to finances, strangely enough. But when you think of it, no court system has an unlimited budget. Money spent on technology in particular is taken from somewhere else. So the first concern was that some councils were worried about the cost of bringing technology even up to date, because COVID did expose on a number of different jurisdictions the fact that technology simply wasn't fit for purpose as of 2020. Secondly, and also in the financial theme, other councils worried about the costs in the future for technological advances which no one can predict. And again, that's simply a known unknown, as an American politician once said. Thirdly, as was pointed out earlier, in fact, in the discussion following Judge De Pasquale's presentation, some councils point to the potential imbalance between technically proficient litigants and their lawyers and those who are not so skilled. Fourthly, there is a concern, and again this was mentioned earlier on, that the challenge of cyber attacks and unauthorized access to litigants' personal data is heightened when you have a fully digitalized system. I mean, the old days when you had a central office of a high court or court of appeal and everything was in writing didn't lend itself to a whole-scale access to the personal information of everybody there. You physically couldn't remove the books. But now you can access data that is digitally held. And we know that that's been done with regard to, for example, health services. Why wouldn't it happen to court services? And then finally, there's the issue of artificial intelligence. The French response to the survey put it this way: artificial intelligence could be an invaluable aid for legal and case law research, as well as for the study of certain very large files. But in our view, artificial intelligence should remain an aid, a support, and not a substitute for human intelligence. That's very similar, I think, to the approach taken by the organization that Judge De Pasquale represents. And as he said in his address, we must resist the temptation, counter the temptation, to have artificial intelligence replace judges. Instead, possibly being conservative about it, artificial intelligence is there to assist judges. In theory, there's a huge difference between assisting the judge and making the decision itself as an AI system. In practice, the difference between AI assisting a judge and making the decision could in fact be wafer thin. Let's take 2 examples. Again, go back to the presentation earlier on today. You could well have a judge who is faced with 15 or 50 cases which AI tells us is decided in a certain way. What's wrong with you if you want to decide it a different way? That's the problem identified earlier on. That involves certainly a degree of courage on the part of the judge concerned. Secondly, and possibly in a less dramatic sense, given the way in which judges throughout Europe are overworked in the main, there must be a huge temptation if you're told that the answer in the last 50 cases by AI has been X, that you would go along with it. That's not to say that judges are lazy, but it is a temptation to operate in that way. So if it's a situation where everything is presented right through to the final decision by artificial intelligence, it takes people of character, which is what judges are supposed to be, to resist the impulse to go along with that. The safeguards suggested earlier on are so important to us all. Let us hope they'll be enough. Let's work towards them being enough. And one final point, a summary maybe. This afternoon, a general election is being called in Ireland. We know this because the Prime Minister announced it yesterday. In the 2002 general election campaign, the governing party's slogan was, "A lot done, more to do." And in a way, that exemplifies or summarizes the position of the judiciary. A lot has been done in terms of innovation. I wouldn't pretend for a moment that there's not more to do. Thank you very much.